The New Jersey versus T.L.O. Supreme Court case took place in 1985. It was between the state of New Jersey and a young teenage girl with the initials of T.L.O.
T.L.O. is a 14-year-old high school student who got caught smoking a cigarette with a friend in a school bathroom by a teacher.
T.L.O. denied she was smoking, and the vice principal did not believe her, so he brought her into his private office and demanded to check her purse.
In her purse, he found a pack of cigarettes and later found rolling papers, plastic bags, a small portion of marijuana, a list of students who owed her money, and a wad of bills.
The school sentenced her with a double suspension, 3 days for smoking on school property and 7 days for the possession of marijuana.
T.L.O. and her lawyers attempted to argue that the school had violated the Fourth Amendment and did not have the right to search without a warrant or her consent. She argued that the vice principal did not get consent to search her purse, and that since the purse is her own property, she had the right to privacy of it.
The school argued in response that they have the right to search because public school officials are considered state agents for the purpose of the Fourth Amendment. They argued that the Fourth Amendment creates no rights enforceable against school authorities.
Justice John Paul Stevens said it was wrong to give students less Fourth Amendment protections than adults. If the nation's students can be convicted through the use of arbitrary methods destructive of personal liberty, they cannot help but feel that they have been dealt with unfairly.
However, the first decision that was made was that the court held up that the Fourth Amendment is not limited to law enforcement authorities. For the first time, the court officially expressed that public school authorities are also state officials. This means that the Fourth Amendment applies to them as well, and they have the right to search with reasonable cause.
The second ruling was with regards to the children's privacy. According to Cornell law, school children have legitimate expectations of privacy, but the school needs to maintain an environment in which learning can take place, and that requires some easing of the restrictions to which searches by public authorities are ordinarily subject. Thus, school officials need not obtain a warrant before searching a student who is under their authority.
This indicates that although students may expect to have complete privacy, they're not always completely entitled to privacy at school, which is state property. The school needs to maintain a learning environment, and public authority figures, such as teachers, are given the right to search with reasonable suspicion.
Another ruling the court sent out was that the assistant vice principal's search of T.L.O.'s purse did not go against the Fourth Amendment because it met a test of reasonableness under a certain circumstance.
There are two factors that make this up. One is whether the search was justified at the start, and two, whether the search was reasonable in relation to the circumstances that justified the interference in the first place.
This case affected the country's future and clarified the effects of the Fourth Amendment. This means that schools have the right to search with reasonable suspicion that a student has violated the law or a school rule, and they do not need a warrant.
If the schools had to obtain a warrant for every search they had reason, they would not be able to respond quickly enough for disciplinary reasons. As a result of this 3-year-long case that was taken all the way to the Supreme Court, T.L.O. was declared a juvenile delinquent and sentenced to a year of probation. Her school tried to expel her because of her state punishments.
This court case ruled that the Fourth Amendment's ruling on unreasonable searches and seizures applies to searches conducted by school public officials and is not limited to searches carried out by law enforcement officers.